Now, we're looking at open justice, and I'm wondering if you could explain how your role has something to do with open justice as a principle.
Certainly. Look, I think the Supreme Court of Victoria traditionally and historically has been very much uh, always advocating, always progressive in terms of open justice. I mean, the predecessor before me, Prue Innes, which a lot of people know of, she was the first court information officer to be appointed by the court, and she was the first such person anywhere in Australia. So Victoria Supreme Court has really been leading the way, has led the way. I've been in this job just shy of 7 years, and I think it's just critical for courts to have people like myself, whatever title we go by. It's all about the day-to-day easy part of the work, which I call the easy part. It really is helping the judges understand the importance of open courts. Not that Supreme Court judges need much advice in that regards here. They're all pretty good. But it's really about facilitating the media. And in this day and age, with so many newspapers cutting back resources, as well as TVs, they're just becoming fewer and fewer on the ground. So really it's up to the courts to try wherever they can, and we, Supreme Court, do really well in getting that information out to the media. It's not about helping the media to do their job, but it's the end result, which is the public understanding the role of the courts, because the public can't come along to the courts every day and sit in trials day in, day out. So we rely upon the media to convey to the public what our work is. And to that end, we make sure that we supply daily transcripts, copies of sentences and judgments, like when they're handed down within the hour, exhibits from trials, all the documents, statements of claims, originating motions in civil trials, but essentially as much material as we can get our hands on and from our open files that we can assist in getting to the media, because then if they've got that document, it improves their chances of getting it correct in technical, complex matters, but also when they're thin on the ground and they're covering Supreme Court, County Court, Magistrates Court, Federal Court, Coroner's Court, Children's Court, to name a few, as well as 6 or 8 trials just in the first 3 courts, then they just can't be everywhere at once. So it is important, and our courts are, of course, always open, but people can't come to the courts, so we all rely upon the media to do that job.
Great. And Victoria is actually leading the way with social media and allowing people to access the courts via social media. Can you explain how that works?
Certainly. Look, a few years ago, Mark, when I guess Twitter became a role in journalists, and I sort of thought, ooh, and I was hearing bits of stories about, court reporters are tweeting. I thought, good God, what are they doing? So I opened an account for the Supreme Court, and it was the first court to do so 3 odd years ago, and we're just coming under 3,000 followers, which is fantastic. And it was initially to see what the court reporters were filing, because I thought, oh heavens, if our judges hear about that, they'll send them back 6 years. And to my surprise and delight, the tweets that the journalists are posting are very, very moderate, very, very tight, and they're just like mini radio reports. So they're just filing factual information. And I then, once we had the account, I said to the Chief Justice, let's trial this, and she goes, yes. So I started posting her speeches. And now it's become an integral part of our communication tools, in that I will post sentences, judgments, announcements, and factual information. And the media, we've just finalised or reviewed our media practices and policy documents, where we now say media can use electronic devices in court, and that means that they can do live text-based reporting. In other words, they can write their stories in court with an iPad, send it to their newsrooms, and the newsrooms can then edit it and put it up online. They can tweet, so they will often tweet. don't tweet much with a jury, but they will tweet things like, jury's about to return with a verdict, or the accused is about to be sentenced. Just really short, factual matters that won't, let them, get undone with anything damaging. They don't blog. I think they're so busy reporting that they haven't got time to do blogs. And that's the one thing that we don't allow public interaction if they do want to do a blog on big cases. We just feel that sometimes public comment doesn't help further progress, understanding how a court works. It's often just knee-jerk reactions. So that's their only limitations at this stage. The judge still has a say in his or her trial, and if they really don't want any social media to take place or any live text-based reporting, then they say at the start of the trial, no use of any electronic device. Or they might say that for the general public, if the public galleries are full, as was the case with Bailey, and the judge said save for accredited media, and we had accredited the media to use electronic devices and to use social media.
All right. Well, you've mentioned that case. That is probably the biggest case in recent history in Victoria, related to the trial of Adrian Bailey over the murder of Jill Marr. And we've also just had a journalist, Darren Hinch, released from jail for breaching a suppression order related to that case.
Yes.
I won't go into the particularities of that, but nevertheless, it seems that open justice works reasonably well, but the justice system will come down heavily on those who abuse the privilege. Yes,
absolutely, Mark. I think Bailey was an exceptional case on so many fronts. I've got very personal views on the breaches of the suppression order, and I feel that Hinch wasn't alone. But it was just huge. I mean, there was 44 media in the court for that day. So you're talking about, sizes of recent case up in Queensland, Daniel Morecambe. I mean, that sort of media pack. And it is just so hard to manage, particularly when you get so many journalists from interstate and indeed overseas, as we did from Ireland, and you don't know them on a personal basis. So hence we did the accreditation to know them all and give them the run through as to any orders that were in force or not in force. And it was difficult because there was so much pre-publicity, and I guess you get into that area as to it was preempting a court decision. What started the ball rolling? We notified media that he was coming into court at a certain time, and media speculated that he was pleading guilty when there'd been no advice given to anything. And, he could have woken up that morning and said to his counsel, I've changed my mind, I'm actually now going to contest that, by which stage all the media had him pleading guilty when he hadn't been formally arraigned. Yes. So the Bailey case caused a lot of difficulties at that start because he was coming to court unscheduled or out of the time frame. And so media did speculate that he was going to plead guilty, which is their right to speculate, but to then put it into print and put it into headlines to me personally, was another matter altogether. And I had actually told media, do not read anything into this because it's tomorrow morning. He might wake up in the morning and change his mind. I cannot confirm or deny what he's doing tomorrow other than he's coming to court. And they just ran with it. One paper started and they all just followed like sheep. And it's very, very difficult because by rights he could have changed his mind and it could have turned back into a trial. In which case then counsel would have been up asking for a permanent stay and there would have been all sorts of problems. And that was the start of it. And that basically, in that case, got the judge angry, to put it bluntly. So he then slapped an order on the plea hearing, a big blanket order, because he was angry with the media having preempted court business. And he just went, so he did from the start, and he just did a total blanket ban. And then at the end of the hearing, he lifted it and to allow reportings of certain matters. So he didn't allow for any reporting, contemporaneous reporting during the hearing. And I guess, you know, people like Hinch got caught up in what was suppressed and not suppressed in the timing and everything. But it really was a difficult case, and on reflection, I think more media probably breached it. That's just my own personal opinion. It's not the court opinion. Look, certainly the judge reviewed every media in it. And, you know, where do you draw the line?
Well, I think that becomes a big question with all of those cases, and clearly they drew the line there with Hinch.
Yes.
Just to finish up, I just would like you to explain, if you don't mind, just a little bit further about what is and isn't allowed in a standard Victorian court case, because
Certainly.
It varies markedly between states and territories. So you're saying now that journalists with mainstream media organisations are allowed to tweet during proceedings?
Yes. Yes, yes. Look, Mark, we still in Victoria, we have the golden rules of for any budding court reporter in your class that might want to go into journalism. You still have the golden rules of not printing anything said in the absence of the jury during a trial. That is still very much golden rule and very much adhered to. That can abort a trial, and that has happened once during my time here. So generally with a jury trial you have to be very careful, but you can report anything that is said before the jury. Pre-trial arguments and voir dires or basher inquiries are still are no-nos for court reporters, because the jury is literally days away from being impanelled, so it's considered sub judice. In a civil case, it's a little bit different because you haven't got a trial, so therefore you've got the files being presented, and again, anything that is tendered in court, relied upon in court, sworn in court, then we make that available and accessible to media if they desire it. But with juries, it literally is anything that is said before that jury. Often juries come in and out of court where counsel will then argue legal points before the judge, then that cannot be reported. But media may take notes and may use it after verdict and, you know, given a colour piece of the trial as to some of the difficulties during that trial and the issues that were raised. But it's very difficult. Well, it's easy and hard in that regards. The actual jury you cannot identify in any way, shape or form, and that includes vision of coming in and out of court. There's very little else that is contained in Victoria. Victims of sexual assault, I think that's pretty nationwide. They cannot be identified. So if they're standing up in court in a rape trial, they can't be named or identified. And generally, sort of minors can't be named either. But once you've got a jury and in the openness of the court, it's anything that's said.
Well, that's fantastic, Anne, and I really do appreciate you going through this for us. It's a fascinating role you have, and a very important one as a strategic communication manager, or what is known in some places as a public information officer in the court. It's an important role, and we do thank you today for going through it with us.
My pleasure, Mark, anytime.